Hi, my name's Isaac Shutt. I'm an estate planning attorney. I'm licensed to practice law both in Texas and in Wyoming. And in this video, we'll talk about one of my favorite things in the whole world, and that is the living trust, sometimes called the revocable living trust or just a revocable trust, but it all means the same thing. And a question that we get almost every day is, how do I fund the trust? Now, if you're not familiar with that terminology, funding the trust means putting stuff in the trust. And the reason that's important is because when you create a trust, meaning when you go to the lawyer and you have them prepare a trust document for you, that doesn't pull in any assets. That's right. Just because you've set up a trust, it doesn't pull in or suck in the ownership of any of your assets. You have to use external things to push the assets into the trust, to put the things in the trust. When you first establish it with your attorney, you've just created an empty vessel, and now you've got to put the stuff into it. And putting the stuff into it is called funding the trust. Now, this is something that people get wrong all the time. You know, we'll see Granny come into our office and she says, look, I paid $10,000 to some attorney to prepare a trust for me. And what's in it? Well, I don't know. You should know that, Granny. You're the one who created the trust. You should know what you did to put stuff in it. But so many times what we see is the person never funded the trust, meaning the vessel is empty. There's nothing in it, which means really you have a $10,000 fancy binder. So that's not great. So let's talk about how to make sure that doesn't happen to you. So to fund the trust, you have some steps after you create the initial trust document with your estate planning lawyer. Okay, so usually when we do a revocable living trust for the client, we'll ask them if we can go ahead and put their real estate into the trust, especially their homestead. So most of our clients own their home, and so they'll ask us to create a deed. And when we create that deed and then file that with the county, that funds the house into the trust. So that's easy. That's pretty much automatic when we first establish the trust. So that takes care of your homestead. Well, then that leaves the cars. Now, the cars you can deal with in a couple of different ways. One way is to actually change the ownership on the title of that vehicle to make the trust listed as the owner. Now, that's a little bit of work, and sometimes it's more work than our clients want to do for the vehicles, which usually overall are not worth a whole lot, but you can do that. Another option is the state of Texas does offer a transfer on death document for the vehicle. So you can also fund the trust using that transfer on death document, and the DMV does have a form to accomplish that. That's a really popular way. In fact, the internet, the website for the state, the DMV, they have a downloadable PDF for you to fill out to transfer the ownership upon your death into the trust. And that's an easy and really cool way to handle that. But honestly, in terms of the vehicles, most people do nothing. And honestly, I'm not mad about that. It's actually not so problematic if they don't put the vehicles into the trust, because A, they're usually not worth a whole lot in the big picture, but B, they're relatively easy to deal with using Department of Motor Vehicle forms without a probate if you die. So if all you had in your name when you passed away was the vehicles, that in and of itself would not create a need for probate. So if the vehicles didn't get put into the trust before you passed away, it's not that big of a deal. Your family would just fill out some forms and that will take care of the vehicles after you pass. So not a huge deal, but those are the options for the vehicles. So for most of our clients, we've already talked about your real estate, your vehicles, and that's usually going to leave the accounts. Now, funding your accounts into your living trust can take shape a few different ways. And I'll give you the good, better, best way. Starting with the worst, the good way. That would be doing nothing and just leaving things as as they are right now. Now, what would happen then is if you pass away and those accounts still show your name as the owner at the time of your death, your family's probably going to have to do a probate of your will. Now, that's not the end of the world, but it's going to cost a few $1,000s probably, and it's going to create a delay in time. So it'll happen. We will probate that pour over will if you pass away, and that will pour over those accounts into the trust after you pass away. So that is an option, but it's the least good option because it's going to cost your family a bunch of money and take them a bunch of time after you pass away. So another level up from that is to utilize beneficiary designations on all of your accounts. And basically what you're going to do there is go into your account settings with your financial institution and change the beneficiary designation to say, hey, when I pass away, instead of it going to no one or to my estate or to just one relative, you actually list the trust as the beneficiary upon death. Now, that's super easy to do. In fact, I was stunned when my wife and I created our trust and we updated our financial institution with our beneficiary designation. I got an email by happenstance from the financial institution and they said, Isaac, would you like to update your beneficiary designations? And I went, why, yes, I do. I would like to update my beneficiary designations. And they said, okay, well, you have your wife as the primary beneficiary. Is that still okay with you? And I thought, yep, that's perfect. Okay, well, do you want to have any secondary beneficiaries? It asked. And I said, yes, click the button for that. And then it said, is that secondary beneficiary an individual or a trust? And I went, this thing is reading my mind. And so I went, yeah, absolutely. I would like to list my trust as the alternate beneficiary. And it just asked me to type in the name of the trust, hit submit. There was a confirmation screen that said your wife is the primary beneficiary. The trust is the secondary beneficiary. If that looks good, hit confirm. And I hit confirm. It took about 20 seconds for me to complete. I know you can do that as well. So that is sort of option number 2, is to use beneficiary designations to fund the trust upon your death. That's super easy to do and avoids probate. Now, the third option is technically the best option, and that would be where you actually go to those different accounts and you say, look, I actually want my name off of the account altogether. So I don't want to be listed Isaac Shutt as the owner of this account at the financial institution. Take my name off right now, not at death, right now as the owner of that account. And so by doing that, I've immediately funded that account. So that's really the best way to go. And the reason that that is the best is because if I become incapacitated, so it's not just if I'm deceased, what if I'm just incapacitated? Well, if it's already in the trust, the successor trustee who's listed in my trust document can seamlessly take over managing that account and helping me pay bills as my trustee. And so that's kind of a benefit there. Now, with that third option, you have to be really careful because qualified accounts, which are 401ks and IRAs and all those kinds of things, that gets pretty sticky. Listing those as the owner of, listing the trust as the owner of your IRAs, 401ks, there can be tax problems, potentially really big tax problems to putting those types of accounts in the trust immediately. So when you look at the options for funding your accounts into your trust, really my suggestion is maybe have a list when you talk with your estate planning attorney to create the trust of where you have your different financial accounts and what type of accounts they are, and just get some advice from that attorney about which accounts should be funded now, like where you change the owner right now, versus which ones should be using beneficiary designations. And that attorney will use experience to say, well, I would recommend this for that account, that for this account, and make recommendations account by account. And honestly, either way for you, it's not super difficult. So as long as you know what you're doing, funding immediately or funding upon death, You can carry it out. I promise you. It's not rocket science. You can handle it. But the most important takeaway from this video should be that when you create your trust document with your attorney, it does not pull in all of your assets. You have homework. You need to do things to push assets into the trust. Otherwise, you've just got that empty vessel. So a lot of times when we do our estate planning with our clients, we will ask them if they would like our assistance, and we're glad to help in funding the trust. So some people want to save money, which we totally understand, and they would rather handle the funding on their own. And so they'll just get our advice for how to fund each thing. And then we have other clients that say, you know what, I trust you guys. I'd rather you guys help me fund that, and I'm willing to pay for that to make sure it's done right. Either way, it's great. But the moral of the story is that you need to get it done. If you have a revocable living trust, you need to make sure that you've done your homework to put stuff in that trust. I hope you found this video helpful. Again, my name's Isaac Shutt. I'm an estate planning attorney who's licensed to practice law both in Texas and in Wyoming.